Good afternoon, everyone. Thank you for everyone for attending today to our webinar. My name is Jim Bablis. For those of you that don't know me, I'm Special Counsel here at Harwood Andrews in the Workplace Relations team. And with me today, I also have my colleague Sonia McCabe, as well as Matthew Sinaratsky. Today, we'll be doing a webinar presentation on essentially a very critical and important topic, and it's really the recent updates of the Fair Work legislation, the Secure Jobs and Better Pay legislation that came into effect just a couple of months ago. Obviously, it's a very important and seminal topic, and we're going to be essentially covering, I guess, 4 key components of the presentation today. I'll be focusing on bargaining disputes as well as supported bargaining before my colleague Sonia McCabe moves on to fixed-term contracts, and when we finally conclude with Matthew Sinaratsky presenting on flexible work arrangements. For all participants, obviously feel free to fire away with some questions, and we'll do our best to obviously address them during the course of today's presentation. And also for those in attendance, please do note that a copy of the slides as well as a recording of the presentation will be made available post the presentation today as well. Listen, I think we might really kick it off for today. I guess one of the first key questions that really does arise is what is the reasoning behind the changes? And you could probably see that we've got obviously the topics there, but we might just move over to the next slide and really cover what the reasoning for the changes actually were. The Fair Work legislation amendment really was designed to incorporate, I guess, some main objectives relating to Australia's changing workplace relations landscape. And specifically, I guess this was a key election issue and election promise from the ALP when they were still in opposition. And really, we could probably bring it down to 5 key themes. Number one, wages, particularly, I guess, to get wages moving, specifically in industries and sectors with a higher than proportion of female workforce. And I think that was really one key objective. The second objective was really to close the gender pay gap and to take steps to prioritize, I guess, gender equity and gender equality in the workplace. Third, to obviously improve job security. Obviously, this has been an ongoing discussion for some time, but specifically, I guess, issues when it concerns fixed-term contracts, as well as casualisation of the workforce, has been a theme and discussion point for some time. So obviously that was another key objective as well, particularly, I guess, with the last few years with COVID, there had been a significant increase in the unemployment rate as well. Number 4, to improve workplace conditions and protections. And I think when we begin to look at that theme, there's a number of themes that we could probably draw out from that, such as flexible work arrangements as being one. And last, I think the 5th important point was probably around more industrial relations, and that was to remove the complexity and barriers to enterprise bargaining. Specifically, I guess, when we're looking at enterprise bargaining, it is still a significant amount of the workforce is still covered under enterprise agreements, but there had been obviously some issues in relation to trying to, I guess, draw them back a little bit to make them more complex and more speedier. So bargaining disputes is the first key topic that we're covering today. And really, what is the background when we're talking about bargaining disputes? We might just move, to the next slide here. Previously, as many of you might be aware, or those of you that aren't, bargaining disputes were dealt with by application under Section 240 of the Fair Work Act. And essentially, these applications dealt with what were termed, at least until very recently, serious breach declarations under the Act as well. And historically, these applications are essentially dealt with disputes where the parties raised issues of not bargaining in good faith, or where there was real issues of inefficiency in the process as well. And where we did see this is usually delays in considering and responding to logs of claims, such as employers, where there was delays, or even proposed clauses, obviously, not being shared in a process that might have been timely. And that was obviously always a big issue, specifically for the unions, that the process sometimes was stalling a little bit where initially there was a lot of headway was actually being made. So the new amendments essentially now change the way the Fair Work Commission will actually deal with these type of bargaining disputes. We'll just move to the next slide, thank you. And once a serious breach declaration was made and issued, the Fair Work Commission would then proceed to make a bargaining related workplace determination under Section 269. However, this was actually a process that was not really utilised all that much, and historically, I guess, unions would really be forced to undertake some type of industrial action to force a settlement of bargaining. Now, as per the recent amendments, serious breach declarations as well as bargaining related workplace determinations have now been repealed. So this then raises the next question: what has actually replaced them? Well, in short, the Fair Work Commission will now have greater powers to resolve bargaining disputes, including where they will have to issue intractable bargaining declarations, after which the Fair Work Commission can effectively arbitrate. Now, the Fair Work Commission can also make an intractable bargaining workplace determination if the parties have been bargaining for at least 9 months. And on that last particular point, it's really to address those issues of bargaining taking a little bit too long. And we'll address some of those issues during the course of the presentation today as to why bargaining has taken long across most sectors in recent times. If we could just move to the next slide, thank you. So why has this change occurred? And I think we could probably categorize this into 4 key themes. Obviously, government has actually been concerned for some time that bargaining has become protracted. I guess the last major rounds of bargaining from 2020 to 2022 has seen parties face, I guess, the following challenges. Number one, significantly more meetings due to online bargaining. And this was, probably speaking anecdotally from some background that I've done recently, particularly in public health EBAs, where there was bargaining for at least 1 year. The citywide EBA as well, for those of you that might have been aware through maybe dealings with the ASU, that was also a protracted bargaining period that lasted for almost a year and at the end was not approved. There's also, the second point is that there's also been an increased use of former Fair Work Commission members as facilitators, and that has led to additional costs. And I know some of you in attendance today may have had some experience with that as well. There's also been, number 3, a significantly higher number of applicant claims in some EBAs, and I might be speaking a little bit anecdotally as well. In some instances, for instance, in public health, there's been at least 200 claims. In many other EBAs, there's probably been a little bit less, maybe 20 or 30, but there've been much more pointier claims. And that has obviously led to significant delays. And number 4, and I think this is probably the one that's been more topical probably over the last 12 months, which is significantly higher wages and allowance claims, which are really linked into inflation. Now, obviously, inflation is a very big topic right now. There's a number of factors that have come into play, such as increased energy costs, mainly caused by the Ukraine conflict. But obviously, that has actually had some implication towards bargaining as well, and delays. And we also saw this with the citywide rollover EBA being rejected. And we've just included a link there for anyone who has interest to really follow it, to see some of the press releases as to some of the factors and causes as to why that EBA didn't go over the line, and how wages and allowances were really one of the factors and how that tied into inflation. We might just move over to the next slide, thank you. So Section 234, which we've put up on screen, really is the process for the applications for intractable bargaining declarations. Essentially, we'll cover this in a little bit more detail in a couple of minutes when we go through the summary of this. But essentially, I guess the key component of this is really number 2 there, where an application for an intractable bargaining declaration must not be made in relation to proposed multi-employer agreements unless the support of bargaining authorization or single interest employer authorization is in operation in relation to the agreement. So there are, some factors that need to be considered, and Section 234 is probably the first key step in the process here as well. We'll just move to the next slide. Section 235 deals with situations where the Fair Work Commission may make an intractable bargaining declaration, and realistically, some of the factors and matters that the Fair Work Commission must actually consider. And number two is obviously the critical component of this in terms of what the Fair Work Commission must be satisfied of. And there really are three key points. Number one, that the Commission has dealt with the dispute about the agreement under Section 240, and the parties that participate in the Fair Work Commission process to deal with the dispute. Secondly, that there is no reasonable prospect of the agreement being reached if the Fair Work Commission does not make the declaration. And lastly, that it is reasonable in all circumstances to make the declaration, taking into account the views of all the bargaining representatives for the agreement. So subsection 2 is really the key component in terms of when the Fair Work Commission may make an intractable bargaining declaration. We'll just move on. And the next component is what happens after the declaration is made. Essentially, the Fair Work Commission will then be obliged to consider whether to provide the parties with a further period to negotiate. This is known as the post-declaration negotiation period. And the key component is the new Section 235A, which deals with the post-declaration negotiation period, and specifically when the process actually starts and what the Fair Work Commission must actually consider. So we've put that up on screen, but these slides obviously will be shared as well. We'll just move to the next slide. And this is really the summary of what the Fair Work Commission must actually consider before making a declaration. And we could probably categorize this in the following points. The Fair Work Commission must be satisfied that before making an intractable bargaining declaration, that firstly, it has dealt with a dispute, for example, by conciliation under Section 240. Also, secondly, that there is no reasonable prospect of an agreement being reached if the Commission does not make the declaration, as indicated a little bit earlier on, and it is also reasonable. So these are the important factors, just in summary. We'll just move to the next slide. And the next component is when the Fair Work Commission must actually make an intractable bargaining declaration. And essentially what this comes down to, as we've placed on screen here, the Fair Work Commission must make a determination as quickly as possible after making a declaration. The factors that must be considered must essentially be in relation to the terms of the determination need to include the merits of the case. The public interest test must also, and productivity test must come into play as well. And the interests of the employees and the employers who will be covered by the determination must essentially remain unchanged. So they're essentially the factors that are very, very critical. We'll just move on. Section 269 is when the Fair Work Commission must make an intractable bargaining declaration here. And essentially, in short, realistically, as we've placed up on screen here, it really must be a process that is actually done as quickly as possible. Is that there is, if there is a post-declaration negotiating period, what that period actually is, and otherwise, shortly after making the declaration as well. In short, this section here really expands the power of the Fair Work Commission to intervene in bargaining disputes when the bargaining parties cannot reach an agreement. And this will allow the Fair Work Commission more scope to intervene in really those long-running dispute matters. And if necessary, essentially try to bring the bargaining to an end by making this determination. In the past, this power was very, very limited. And as indicated a little bit earlier on, unions were more inclined to actually enter into industrial action and strike periods to essentially force the issues across. The next component of this really is just in a quick summary. In making this declaration, the Fair Work Commission may specify the post-declaration negotiating period, and it also must include situations where it also is a period where the Fair Work Commission will not make a determination, but may still obviously provide other assistance to the parties, such as conciliation. So it's not a given that the Fair Work Commission will step in. Conciliation is obviously the first port of call in these scenarios. As with the existing serious breach declarations, protected industrial action cannot be undertaken when the declaration is in place. And the declaration will cease to operate when any employer specified in the declaration is covered by an enterprise agreement or when a workplace determination is made by the Fair Work Commission. So essentially, I guess, when we're looking at bargaining disputes and the recent changes, the key component I think that must be taken into account by everyone is that this is historically was a section of the Act that was not utilised all that much, because historically the unions would fall back on industrial disputes and industrial action as a form of getting their message across. But as we're currently seeing, the Fair Work Commission has introduced a process which at first will encourage some degree of negotiation among the parties, secondly conciliation, and thirdly will step in and make these declarations. And that essentially is the objective of these changes. We might just move over to the next component, which is supported bargaining, which is obviously the next key component of the changes. Now, where do we start with this? So the new Act has essentially, as we've placed up on screen, has repealed the following definitions from Section 12, which is the definition of consent low-paid workplace determinations, also the definition of a low-paid authorisation, the definition of a low-paid workplace determination, and the special low-paid workplace determination. In its place, what has occurred is that it has included supported bargaining agreement, and this essentially is a situation where a multi-employer agreement is essentially is a supported bargaining agreement if a supported bargaining authorisation was in operation in relation to the agreement immediately after the agreement was made. So in short, what does this all mean? In short, the previous low-paid bargaining scheme is now known as the supported bargaining agreement and will have lower barriers to entry. The Fair Work Commission will also be able to make a supported bargaining authorisation for multi-employer bargaining, specifically in lower paid industries, if it considers it appropriate, having regard to essentially to a number of factors. We could just move on. So what was the rationale for the change? Essentially is probably the next key component. The explanatory memorandum to the bill suggested that the purpose for the new stream is to assist, employers and employees who may have difficulty bargaining in the single enterprise level, such as though in low-paid industries who may lack the necessary skills, resources, and power to bargain effectively. And when we're particularly talking of these sectors, I think there are some sectors that probably come to mind. Aged care is probably the one that I think is most prevalent. Disability care and early childhood education and care are also specifically mentioned as examples. There has been other mention of other industries as well, probably smaller transport and logistics companies, but I think aged care is probably the sector that we would probably see the most movement in relation to, and the rationale for the change. And how would effectively this work? For a supported bargaining agreement to be made, the Fair Work Commission would first need to grant a supported bargaining authorisation, which could be sought by an affected employer or union or another bargaining representative for the agreement. So that's actually how it would actually work. And the next slide is just a quick summary and screenshot of Section 243, which deals with the factors when the Fair Work Commission must make a supported bargaining authorisation. We might just continue that slide. It does continue, obviously, that the Fair Work Commission will also look at the common interests, and specifically common interests, which we'll cover in a bit more detail shortly, will also include, for instance, a geographical location, which is obviously a very big factor, specifically in sectors that have some degree of geographical remoteness, the nature of the enterprises to which the agreement will relate, and the terms and conditions of employment in those industries. And as indicated a little bit earlier on, I think aged care is probably the key one that we can identify. And also being one of the other factors is being substantially funded directly or indirectly by the Commonwealth, a state or a territory. And that is specifically around sectors which have a significant amount of government funding attached to it as well. So that would obviously be part of the common interest. Thank you for that. And we'll just continue on to the next slide. So the 2B is obviously the next component of this. It's obviously very, very important. And this is where I guess the minister may obviously intervene or there might be some authorization as well. So there are obviously other factors to consider, but the authorization also, when granted, must specify obviously the employers that will be covered by the agreement, the employees who will be covered by the agreement, as well as any other matters prescribed by procedural rules. And when we're actually thinking this, it's specifically around issues around natural justice and fairness to those cohort of employers and employees. So I'll probably get back to what this all means for everyone. So what must the Fair Work Commission essentially consider? There's probably 4 key themes to this. The Fair Work Commission will essentially be required to make a supported bargaining authorisation if it is satisfied that it is appropriate for the relevant employees to bargain together when considering the following factors. Number 1, the prevailing pay and conditions in the relevant industry or sector, including and specifically whether they are actually low rates of pay prevailing in the industry or the sector as well. Throw it back to, I think aged care is probably the one that really does ring a little bit. Number 2, whether the employers have clearly identifiable common interests, which may also include geographical location, the nature of the enterprises to which the agreement will relate, and the terms and conditions of those enterprises. 3, whether the likely number of bargaining representatives is actually manageable. And I think that is going to be, I think, a key theme in all this. And lastly, any other matters the Commission considers appropriate. And I think that's specifically in scenarios where the Fair Work Commission may exercise a degree of discretion or insight as to why these authorisations are important. In terms of, I guess, where we're seeing a bit of movement and where we will see some movement, I think it will be in those first 3 key points there. I think the Commission may want to issue these authorisations, particularly where it does identify that certain employers and employees are at a geographical risk, or they're in high-risk sectors, and obviously where they will need to have some degree of management around their bargaining representatives. Now, I might pause there because I will now pass over to my colleague, Sonia McCabe, who will move into the discussion around fixed-term contracts. Thanks, everyone.
Thanks, Jim. And hi, everyone. Thanks for joining us. I will be talking about the amendments that have been made in relation to fixed-term contracts, or as I'll talk about a bit as I go forward, I might start calling them term-based contracts, because we'll see these amendments aren't just about what we would typically call fixed term. A little bit of an overview just to start. These provisions that I'll be talking about will be commencing on the 6th of December this year. So towards the end of the year, we'll see these come into effect. I'll go through in a little bit more detail as we go through some of the reasons why these changements have been made and what they actually are, but very broadly, these are changes that are made to increase job security. And the primary purpose of the changes is to prohibit entry into fixed term or term-based contracts in certain circumstances and subject to various exceptions that we'll go through. So the reasons for these amendments, really this is based on some policy commitments that were made as part of the 2022 election, that the government intended to tackle insecure employment, including what are called the abuse of fixed-term contracts of employment. Tony Burke, in his second reading speech, spoke about this further, and in particular talked about job insecurity in the context of rolling fixed-term contracts, which he said effectively amount to a permanent probationary period for employees. And he said all legitimate forms of employment, which can include fixed-term employment, have their place, but where there is abuse, we must curtail it. This was again then reflected into the explanatory memorandum for the new legislation, where again that picked up the idea that fixed-term contracts exacerbate job insecurity for employees, where they use for the same role over an extended period, or where there are rolling contract renewals for a job that would otherwise be ongoing. There is also a gendered aspect to this, in that the government has said the primary cohort of employees who are impacted by insecure fixed term employment are women, because more than half of all fixed term employees are women. The main amendments that are made by this part of the amending Act is to insert a new Division 5 into Part 2.9 of the Act, the other terms and conditions part of the Act. We get a little guide that will be inserted into the Act. The primary section that will be inserted and that we'll focus on mainly is new section 333E, which is called limitations. And this is a section that sets out when the entry into a contract of employment that is a fixed term or term-based contract will be prohibited. This section will be set out in the slides, and you'll receive them, but for the sake of a little bit of ease going through them, we'll talk about this in terms of a bit of a flow chart, so that you can go through this as a bit of a question and answer exercise to work out, subject to the exceptions that we'll come to, when is it unlawful to enter into a contract of employment that meets these characteristics. So our first question that we'll need to ask is, are we entering into a contract of employment with an employee that provides for termination at the end of an identifiable period? And that will capture more than just a fixed term contract. It will capture things like maximum term contracts, some others we'll talk about. If we don't have that, this division of the Act doesn't apply, so we don't need to worry, and you can move on. However, if you are entering into that sort of contract, the next question you would ask is this a casual employee? The limitation, the prohibition doesn't apply to casual employment. So again, if you've got a casual employee, you're okay. If you have a part-time or full-time employee, then the next question to ask will be, is the identifiable period in this contract more than 2 years? If it is, that contract will be prohibited, subject to any exception. So a key aspect of these rules is that long-term, more than 2-year fixed term contracts will be prohibited. If our term is less than 2 years, our next question is whether the identical period of this contract plus any period in the contract for extension or renewal will be more than 2 years, or if our contract provides for an option to extend or renew more than once. So if we have a contract for 1 year, but it's got an extension option for another 12 months or more, or we have a contract for, say, 3 months that provides for 2 options for renewal, even if that will in total be less than 2 years, this sort of contract will be prohibited, again, subject to exceptions. If that's not the case, we move on and we'll need to ask, was there another contract of employment between the same parties for an identifiable period? So is this the second fixed term or identifiable period contract being entered into with this particular employee? If there was, we'll need to check whether the previous contract was for the same or substantially similar work. If it's not, we're okay, but if it is, we'll then need to look at whether there is substantial continuity of the employment relationship between the parties during the period between the last contract ending and the current contract coming into effect. And we'll come back and talk about what that might mean. If we have that, we'll have a question about whether the period that the previous contract was in effect, plus the period of the current contract will be greater than 2 years. And again, if we have that, there will be a contravention unless there's an exception. If not, again, we're looking at whether the current contract contains an option for renewal or extension. So we're essentially saying if there was already a previous contract, this is the second one. If there's then another option for extension or renewal, that will be prohibited. Again, we look at whether the previous contract contained an option for extension that has been exercised. So is this an extension? If so, that's a contravention unless an exception applies. And otherwise, we'll have to look at finally whether the previous contract had come into existence after another contract that provided for termination at the end of an identifiable period, so another fixed term or maximum term contract. that was for the employee to perform the same or substantially the same work. And there was a substantial continuity of employment between the two previous contracts. So again, there, if that's the case, we will have a contravention unless there's an exemption, and if not, we're okay. So it is fairly complicated set of limitations. There'll be a bit to work through each time you're looking at a new fixed term contract. Talking about what some of those terms will mean, when we're looking at, as I mentioned, a contract that will terminate at the end of an identifiable period, this is where I take a little bit of issue with calling this the fixed term contracts section of the Act, because it does apply to both fixed term contracts, or what we would call a contract for a specified period of time, a maximum term or outer limit contract. So that's one that will have an ability to terminate on notice within a maximum period of employment. Contract for completion of a specified task, a contract for the duration of a specified season, or something like a daily hire contract. So it will cover a raft of different contracts which the end date or the maximum end date is identifiable. Another sort of new concept in these amendments is this idea of substantial continuity of the employment relationship in the period between two contracts. So the explanatory memorandum tells us that when we're thinking about that, this insertion of this concept is intended to make sure that periods between contracts that aren't intended to end the relationship between employer and employee don't break the connection between the contracts. So, for example, in an education context, there's often term-based contracts that are used, and one contract that finishes at the end of one semester, and then another that starts at the beginning of the next semester would fall within this idea of substantial continuity of the employment relationship. There might be some other examples that we'll see as time goes on. For example, where an employee might finish one contract and then take some time to look after some family members. They might be ill or injured, or there might be a break between periods of seasonal employment. For example, where someone is a fruit picker and in fruit picking season they're engaged, and they're not for the rest of the year, but they come back end on end each year. Or other breaks between engagements. For example, if there's an events manager who's engaged for each event or something like that, that might fall within these concepts. We also have a concept when we're talking about what could be called rolling contracts, or where there's a replacement contract being entered, the question of whether the previous contract was for the employee to perform the same or substantially similar work. And that's probably sounds deceptively easy, but there's a few different ways that you can think about whether work is the same or substantially similar. The explanatory memorandum to this piece of legislation, these amendments, tells us that it's likely that this is intended to refer to whether the work duties are the same or substantially similar, and that's probably the obvious thing that would spring to mind. However, I will just flag in a couple of other sections of the Fair Work Act, we already have similar phrases in slightly different contexts. For example, in the sham contracting provisions of the Act, there is a concept of an independent contractor performing the same or substantially the same work as an employee. And under the transfer of business provisions, there is again a concept of the work that a transferring employee performing being the same or substantially the same as the work the employee performed for an old employer. Case law under each of those sections will give us a slightly different answer as to what that phrase means. So we might find that here, this idea of the same or substantially similar work has a slightly different meaning to what it does in other parts of the Act, and that'll be a bit of a watch this space. If we are initially falling foul of the limitations in section 333E, there are exceptions set out in section 333F of the Act post the amendments. These will generally tell us that it will be okay to enter into a fixed term or term-based contract that is for the employee to perform a distinct and identifiable task involving specialised skills. So that might be something like genuine project-based work or performance, or to design something or prepare a report. It will be permitted to enter into a fixed term contract for a training arrangement, such as an apprenticeship or traineeship or cadetship. Again, it'll be okay to engage an employee to undertake essential work during a peak demand period. So that might include something, again, like seasonal work, fruit picking or things like that. Could also apply to something like domestic violence services over a holiday period where there might be peak demand. There will be an exception where an employee is engaged under a contract to undertake work in emergency circumstances or during temporary absence. So, for example, to cover a period of parental leave or long service leave for another employee, or perhaps during an absence of another staff member because of workers' compensation or injury. There will also be an exception if the first year of the contract provides for the employee to have earnings above the high income threshold. So that's currently 162,000, but does change year on year. So, for example, you will commonly find that a C-suite employee, for example, might be engaged on a 3-year contract for an income over the high income threshold. So that will actually be permitted still under these new amendments. One that I think will get significant attention as we go forward is that there is an exemption for a contract that is for a position for work that is funded by government funding or potentially some other kinds of funding that might be prescribed by regulations in future. There's none at the moment. If that funding is payable for a period of more than 2 years, and there are no reasonable prospects that the funding will be renewed after the end of that period. The difficulty I think we'll see with that is that because this only applies where the funding has no reasonable prospects of renewal, that's a pretty high bar. I think it's a bit different to, for example, a situation where there might be a reasonable prospect that funding won't be renewed. We also have an exception for a governance position that has a time limit under governing rules, for example, under the company constitutional rules of association, or if the term-based contract is permitted by the terms of a modern award that covers the employee. It's also allowed by this legislation that there may be some further exemptions prescribed by regulations going forward. In relation to the exemption for fixed term earnings that are above the high income threshold, that does allow for pro-ratering for part-time employees, and the explanatory memorandum gives a bit of information about how that can be calculated, as well as a particular section being inserted to deal with that in the Act. And the new amendments also tell us that there will be an evidential burden on employers. Essentially, if you are trying to rely on exception for these sections, then you will bear an evidential burden of proof that you meet that exception. The explanatory memorandum gives us a bit of a handy hint here in saying that it will be best practice for employers to include the exception that they're relying on within the terms of the fixed term contract going forward, as well as the basis on which they consider the exemption applies. So, for example, if you're entering into a new fixed term contract because, and you say it's permitted because this is permitted by government funding, then it will be best, the explanatory memorandum says, to include that in the contract. The amendments also include some amendments to permit the modern awards to allow employees to be employed under a contract of employment that would otherwise be prohibited. This has essentially been inserted because some existing modern awards do contain provisions that permit fixed term contracts. The legislation will permit the Fair Work Commission to insert these kinds of terms into modern awards in future, although my own view is that's fairly unlikely. The explanatory memorandum indicates that that might occur in the event that the Fair Work Commission considers it necessary to give effect to the modern awards objective to insert those terms. It might do so, but the modern awards objectives include security in employment, essentially. So I think that will be fairly unlikely unless there's pretty heavy lobbying. Just set out some examples there, which I won't go into detail, but these are some of the modern awards that do include provisions relating to fixed term contracts already. So if you are in one of those industries, it might be worth having a look at those award terms to see what is and is not permitted post these amendments coming into effect. We also have a bit of a question about what happens with enterprise agreements. So once these amendments come in, will enterprise agreements be able to permit term-based employment? Unfortunately, there's no equivalent term in the amending act as there is for modern awards that expressly tells us that enterprise agreements can permit term-based employment. And we don't have an exception in the new section 333F for contracts that are made in accordance with enterprise agreement terms. So we've previously been allowed to include fixed term arrangements in enterprise agreements. It's a permitted matter under the Act and not an unlawful term. But going forward, it does appear that unless there is a modern award term that covers employees under that particular enterprise agreement that do permit fixed term contracts, it won't be possible to effectively permit those by way of an enterprise agreement. I do think, though, that an enterprise agreement could reflect the underlying award terms and still permit fixed term employment where that is already permitted by the award. If you do enter into a prohibited fixed term contract in future, the new amended provisions will tell us that the term of the contract that provides for the contract to end at the end of the identifiable period will be taken to have no effect. So that will have a few different impacts. It will mean, for example, that the employee will then effectively be entitled to notice of termination at the end of the contract, and if you haven't got an express termination clause in the agreement, then that may be taken to be a reasonable notice period, which for senior employees can be quite extensive. It will also mean that the exemptions from some entitlements under the Act to redundancy pay, and also the exemption or the exception from the meaning of the word dismissed for unfair dismissal purposes will not apply. So if the employee does finish at the date that would have been the end of that contract, they may be eligible to bring an unfair dismissal claim where they currently wouldn't. There is an anti-avoidance provision that will be inserted as well, which provides that a person mustn't do various things in order to avoid rights or prohibitions under this new division. So it will prohibit a person from terminating an employee's employment for a period, delaying re-engaging them, not re-engaging that employee and instead engaging someone else to perform the same or substantially similar work, changing the nature of the work or the tasks the employee is required to perform, or otherwise altering the relationship in order to avoid the operation of these provisions. I will say, though, it's a little bit difficult to see how this will be enforced in practice because this is not a civil remedy provision. So I think although this has been included to avoid as an anti-avoidance mechanism, it may not be as meaty a piece of the new Act as it could otherwise have been if it was made a civil remedy provision. There will also be a requirement to provide fixed-term information statements to fixed-term employees after 6 December this year. We don't yet have a draft of that information statement, but that'll be something to bear in mind as well. And there is a new dispute resolution procedure that will be inserted as part of these amendments that will apply in relation to any dispute between an employer and employee about the operation of this division of the Act. This dispute resolution procedure will require that in the first instance, parties to a dispute must attempt to resolve it at the workplace level. However, if they don't do that, either party to that dispute can refer it to the Fair Work Commission. The Commission will likely deal with these kinds of disputes by conciliation in a similar way that it does, for example, with unfair dismissal and general protections matters. And if the dispute isn't resolved, there is a backstop that the Fair Work Commission potentially can arbitrate the dispute, but that will only be if the parties agree. And it's a similar regime in relation to general protection, where it's very uncommon for that to actually occur because it's usually not in an employer's interest to agree to arbitration in the Fair Work Commission. We also have some sort of technical amendments that confirm that the Fair Work Commission does have functions in relation to this part of the Act. There will also be access to the small claims procedure. That's a procedure that allows claims to be made in, for example, the Magistrates Court in relation to a breach of civil remedy provisions if they wish to apply for some compensation. So that procedure will also now apply to a dispute about whether a person has contravened the new section 333E, the actual limitation, or whether there is a dispute about the effect of entering into the prohibited contract. There will be civil penalties available potentially for contravention of these terms. So for an ordinary contribution, the potential penalties up to $16,500 for an individual or $82,500 for a body corporate. And then in the case of serious contraventions, much larger penalties will be potentially available. These will be in relation to breach of the limitation, so entry into a prohibited contract or a failure to provide the fixed term contract information statement. So what does this all mean? I think there's some sort of practical tips to leave you all with. Worth going through a bit of an audit as to where you currently use term-based contracts and why. Think about, will exceptions apply in future, and if not, what do we need to do about it? Worth having an update to your current contracts to include the basis for future exceptions in there, and being prepared to be providing fixed term contracts information statements after the 6th of December this year. Good time now to start educating your relevant managers and decision makers, including all of yourselves, but more broadly, so that everyone's aware when a term-based contract can and can't be offered. We'll often see that these are offered, for example, in recruitment ads, and then you find out that perhaps fixed term or maximum term employment really isn't the best option. So getting ahead of that would be a good idea. Always good to diarise when term-based contracts begin and expire, particularly now because contracts for more than 2 years won't be permitted, subject to any exceptions. Good idea to be planning in advance the periods that you'll be offering any term-based contracts and whether there will likely be any extensions. And here, because there is a prohibition on more than one renewal, no matter how short that period is, you might find in some cases you're better to offer a longer term up front rather than a short term with the option of renewals. In future, it will be very worthwhile to check for any previous contracts before thinking about offering a renewal or extension, just in case you might inadvertently fall foul of some of these requirements, as well as thinking about what alternatives might there be to term-based employment. Obviously, the intention of these amendments is to encourage ongoing permanent employment, but it might be in specific cases that a better option for employers will actually be to switch to casual employment or even outsourcing to labour hire or an independent contractor potentially. And again, just being aware that a prohibited term-based contract will be converted to a contract for ongoing employment. So being aware that if that does happen in future, obviously the plan is to avoid that, but if we fall foul inadvertently, the end date of that contract won't have any effect. So employees on those sorts of contracts might then be eligible for notice of termination, redundancy pay, and also be able to bring an unfair dismissal application. So at that point, I will hand over to Matt as our next presenter to talk about flexible work arrangements.
Thank you, Sonia. Just get my video going here. Jim and Sonia, just let me know if you can't see that, if there's any technical difficulties, but I think it should be smooth sailing all from here. So fourth and final topic that I'll be presenting on is flexible work arrangements and just the changes coming in that space. So unlike the previous parts of this presentation from Jim and Sonia, these changes aren't in effect just quite yet and won't be until the 6th of June specifically of this year. So obviously flexible work arrangements are currently a thing, and the changes that are coming in June involve mainly the expansion to more employees, lots of important little changes around the procedure of how they actually work, and then also introducing the availability of dispute resolution options for employees who are refused a flexible work arrangement by their employer. So just by background, as a little bit of a refresher of what flexible work arrangements actually are, they come from the National Employment Standards, which apply to all national system employers in Australia, and it's the minimum rights that they get out of that. So employees have a right to request of their employer a change in working arrangements to make it more flexible. And usually what this involves is change of hours, change of patterns of work, or actually where they work. If they actually have the availability of working in different offices or different sites, things like that. So it's not available to everyone. There does have to be certain circumstances to apply to the employee for them to actually use this right to request flexible work. And most of them revolve around kind of caring responsibilities. If you've got to care for someone else or care for yourself. So they're listed there just on the right-hand side in that box. So being a parent of a child, and they have to be school age or younger. So you can't get away with saying that you got to care for your 18-year-old son or daughter or anything like that. Being a carer of someone with a disability, having a disability yourself, being 55 or older, you can request it. Obviously, once you get to that age, you're hopefully looking to start transitioning out of work and into retirement. And then the last two there relate to family and domestic violence if you're either experiencing it yourself or if you're providing care or support to someone who is experiencing it. So it could be accompanying them to court or just going around to their house and providing support of that nature. In terms of the procedure, employers have to have completed and worked with their employer for at least 12 months in order to have the right to request flexible work, and this applies to casuals as well. They just have to meet that 12-month mark. They need to be a regular casual employee though, so a casual who just kind of does ad hoc shifts every now and then, kind of like a contractor, wouldn't be eligible to request flexible work, but a casual who kind of works their 3 shifts a week, roughly, they will be able to request flexible work. So it must be set in writing. Obviously, depending on where you work, you can kind of have pretty loose and flexible arrangements that aren't in writing or don't follow the whole procedure. But proper ones, and if the employer isn't super aware of it, then they should be in writing. And obviously this is going to help both the employee and the employer if there is a dispute about it. And then employers then have the obligation to respond to any request made by an employee within 21 days. And there's rules around if they do refuse it, there is rules around kind of how they do it and what they rely on, which we'll get into in the coming slides. So quickly touching on just the reasoning behind these changes, as I mentioned, a lot of it is based around kind of caring responsibilities. And this is often, more often than not, taken on by female employees who obviously have children or are looking after children. So it was a policy commitment by the Labor Party as part of last year's election. And this one was put into legislation. Obviously, not all promises are carried out once they are elected into government. This one has been. So basically the reasoning behind these changes is to just support gender equality in the workplace, basically allow employees to be able to keep their job, keep it secure, rather than having to quit the job because they have no choice because they've got to take care of their children or something like that. There's been lots of talk about the gender pay gap recently, so these changes will help address that, hopefully. And it was also recognised by the federal government that employees didn't have any course of action if an employer did refuse their request. They basically just had to suck it up, and that was that, unless there was special circumstances like an enterprise agreement. So yeah, overall, it's just going to hopefully make it easy for both employees and employers with the associated benefits of sharing and managing those care responsibilities. So getting into the changes here, the main one in terms of who can actually request flexible work, it's now been expanded to employees who are pregnant. It kind of surprised me that that wasn't in there initially. Obviously, it was already accommodated for employees who are a parent. That's obviously once the child is born. So now it will apply to employees who are pregnant, which is a good change. And in terms of terminology around family and domestic violence, so that will be changing. It used to say, as you can see there in those green rectangle boxes, it used to say, or currently says, sorry, employees who are experiencing violence from a member of the employer's family. However, that's now going to change to employees who are experiencing family and domestic violence. You can see the definition just at the bottom right there. And that definition essentially is just matching up with the new amendments to the Fair Work Act, which I would assume most people have seen recently about the new paid family and domestic violence leave, which is changing from the unpaid leave. And there was a few definition and little changes around terms to expand it more, so it catches more circumstances of family domestic violence, as previously it was pretty strict in what it would and wouldn't apply to. So it'll now apply to circumstances that can include housemates, former partners when you're not living together, and it also recognises Aboriginal and Torres Strait Islander kinship rules and relationships. So a lot more flexible there. Moving on to the procedure and the actual grounds for refusing the request by the employer. There now is a requirement that the employee and the employer have to sit down and have a discussion. So this is following an employee who's put in a request. That previously wasn't a requirement, so now they've got to have a sit down and have that discussion. And the wording of genuine agreement has been added to the legislation. So essentially what that involves is the employer and the employee seriously has to sit down and just try and reach a genuine agreement on what they can do for the employee and talk about their circumstances to try and find a happy medium for both parties, whereas previously the employer could weigh it up themselves and not really have a chat to the employee and just refuse it, obviously on those business grounds, but the employer didn't kind of really get a say in it apart from their initial request. So if there isn't a genuine agreement reached, the employer can obviously still refuse, but they now have to have regard to the consequences for the employee. And again, this can only be on reasonable business grounds, which I'll get into, I think, in the next slide. The 21-day time limit will still apply. So if one of your employees does make a request, you've got a strict time limit of 21 days to apply. Otherwise, the employee will have a course of action after that. So there's the reasonable business grounds there, listed A to E. So these are basically the reasons that an employer has to rely on if they are refusing an employee's request for flexible work. They can't just make anything up. They're listed there. They're not exhaustive, but this A to E will cover probably most circumstances that would spring to mind for an employer if they were going to refuse a request. So you've got things there like cost, impracticality to other workers, which would obviously be relevant if it was a smaller workplace, customer service as well, if it's going to have an impact on customer service, if you're short-staffed or something. And then also just your general loss of efficiency and productivity. So that note there, just at the bottom highlighted in green, that's been added. These reasonable business grounds are still the same as what they are currently, but that new note will be added in June and just adds a little bit more context for both parties in terms of how to kind of gauge these reasonable business grounds. So the circumstances of the employer are going to be relevant, and this includes, as I've just mentioned, the nature of the workplace, the size of it, and things like that. So you're not going to have a strong argument really to say that it's going to be impacting you in terms of short staffing if you do have a workplace of, 30 or more people, for example. On to the next slide. So this is also more changes in terms of if we're getting to the stage where you've had your discussion, you've tried to reach a genuine agreement with the employee, but depending on your circumstances, you might be a workplace of 5 people or so, and it's just not going to work all round for you to have someone who's wanting to kind of choose their days or choose their hours when there's only one other person who could kind of fill in the gaps, if that makes sense. So if we do get to that stage and you need to refuse an employee's request, you've now got to do that, obviously still in writing, but you've got to include a lot more information. You've got to list the particular business grounds, so you might be listing cost, which you did have to do previously, but now you've got to actually explain how they apply. So it's essentially just getting employers to add in a lot more detail there, and just kind of increasing that transparency for the employee so that they don't kind of feel hard done by, and it shows that the employer has actually given a genuine thought to the circumstances. The other thing there is, and this goes back to the notion of having that discussion, is that if there's any alternative changes that could be made to accommodate the employee. So, your workplace might not be open on the weekend, and they might have requested to work on a weekend or around weekends or something. But you could make an alternative change for them that kind of meets in the middle, where they work, extended hours during the week or something. And yeah, if it is refused, you've also got to now explain the available dispute resolution procedures, which have just been added that I mentioned, and that's this 65B and C just there. So, and they'll be mentioned on the upcoming slides, which weren't previously available to the employee. So yeah, as I just mentioned, there was no kind of option for the employee if they were refused flexible work. I guess they would either suck it up or they would just quit. So kind of the policy reasons behind this is that we don't want that happening. I think from both perspectives, you want to keep your workers, and they obviously would want to stay on as well. So the Fair Work Commission is going to be given the powers now to deal with any disputes about flexible work, which they previously couldn't. The only way that employees could kind of dispute this was if it was listed in an enterprise agreement or in an employment contract. So now that it's obviously listed in legislation, it's going to apply to everyone, not just employees that do have a special kind of employment contract or a workplace that has an enterprise agreement. Like most dispute resolution kind of procedures, the parties still need to try and attempt to resolve this at the workplace level within the 4 walls first before taking it to the Fair Work Commission. If a matter does proceed to the Fair Work Commission, it'll go through conciliation first, which is that less formal procedure. And there's a conciliator who's just kind of trying to help the parties to work through it. And if it's not resolved after that, which isn't super common, but it still does happen, then it will go to arbitration, which is where the Fair Work Commission will weigh up the facts for both sides and make orders based on that. So there's the orders. If it does proceed to arbitration, the Fair Work Commission will have any of the following orders available to make to them. So they can state that the employer's reasons, they can basically say that they are reasonable business grounds or that they're not reasonable business grounds. So that will obviously come down to the Fair Work Commission's interpretation. They can order that the employer take further steps to actually respond to the request. For example, they may not have even responded to it. So that goes back to that 21-day time limit where the employee could bring it before the Fair Work Commission. And if it goes to arbitration, then they can force the employer to actually respond to it. They can switch it around that the employer grants the request, which is what happened I've got a case example coming up in the next few slides. They can order that the employer grant the request. And then they can also order that an alternative change to accommodate the employer's circumstances is also put into action. Now, Any contravention of these orders will breach civil remedy provisions, which could attract a fine for either the employee or the employer. So these are the civil remedy provisions and the penalties that apply for that. So for the employee, the maximum penalty, the penalties can range from 16,500 to 165,000 maximum there, or that 82,500 to 825,000 for body corporates, which will usually be the employer. This is obviously dependent on the circumstances, and hopefully no one out there would have to be worrying about this. So I won't spend too much time on this slide. So this is the case example that we've pulled out, and it's Natasha Fife and Ambulance Victoria, which was a case that was decided earlier this year in the Fair Work Commission. So she put in a flexible work request, those two there on screen. The first one was to work night shifts overnight between 9 and 6 a.m. rather than 6 p.m. and 8 a.m. And this was in order to care for her children due to her partner's working arrangements. And that second request there, which was to include weekday, day and afternoon shifts, and then Saturday night shifts, but no weekday shifts overnight. So fairly particular, but she has every right to request those things. These were both denied by Ambulance Victoria, and their reasoning was pretty brief and kind of vague. There's a quote extracted there from their reasoning, and basically they said that they weren't able to provide those customized kind of shift start and finish time outside of the employees, the roster and configuration for her team, and they're not in a position to offer that level of variation. So a fair bit of text on this slide. It obviously went before the Fair Work Commission, and Ambulance Victoria on the left there gave those reasonings, and it was fairly kind of a fair bit of jargon there and kind of that corporate speak, which is fine. But the main thing here is that Ambulance Victoria obviously went into full detail here once it got before the commission. They kind of extracted their whole reasonings in their submissions, but this level of reasoning was not given to Ms. Fife when she initially made the request there. So just to kind of summarize Ambulance Victoria's reasoning there, it doesn't align with their service delivery model, which is to obviously provide safe and compliant health services to the community. And then their rostering is driven by the needs of the community as well. Ms. Fife wanting these kind of custom shifts would cause unfunded costs and unfunded shifts as well for Ambulance Victoria. And lastly, they also said that they weren't opposed to offering Ms. Fife some other kind, like meeting in the middle and offering her some other kinds of flexibility within the funding shift structure. However, as far as I'm aware, this wasn't offered to her at the beginning. So Ms. Fife, on the other hand, she obviously argued against that and said that there wouldn't actually be a significant cost for Ambulance Victoria, and that this would be because the wages paid to her would actually be offset by not paying overtime to someone else. There wouldn't be a need to change the working arrangements for other employees. There wouldn't actually be a loss of efficiency or productivity or a negative impact on customer service. So, because Ms. Fife would basically she was wanting to be put on as kind of a fill to work shifts as needed. So, in terms of the decision, Commissioner Johns was fairly strict in his judgment in saying that Ambulance Victoria's reasons were no more than purported reasons for its decision and not part of the actual reasons. So basically what this meant was, firstly, he wasn't happy with how Ambulance Victoria didn't give a good amount of reasoning in the first place before it went to the commission for its refusal. And secondly, a lot of it, was just in that kind of corporate speak. And to the employee, they're not really going to understand a lot of what that means. And at the end of the day, Commissioner Johns said It's great that Ambulance Victoria said that they weren't able to offer this rostering and that there would be unfunded costs and all that. But he basically said that the question was why not? Why couldn't they offer it? And he held that there was no reason that Ambulance Victoria couldn't have accepted and accommodated her request on the basis that, yeah, she'd be treated as a flexible spare. And she'd actually be more flexible it would be more flexible for her to be on this arrangement for both herself and Ambulance Victoria, because she could work it and was prepared to work at any of the 11 different branches around her. They could have first looked to fill up the 14-hour spot using employees on ordinary time, and then flexible spares like Ms. Fife could be rolled up and used in that sense. They were saving there on overtime, and then as a last resort, they could use her on at least 9-hour shifts out of the 14-hour spot rather than having that whole spot vacant entirely. So she could work a shorter shift and it would still work out. So that graphic there on the right-hand side, so in a little bit of humour in the judgment, Commissioner Johns actually likened Ambulance Victoria's reasoning to the famous Computer Says No quote from the show Little Britain. And they basically just said it goes along that same reasoning that their grounds for the refusal was basically just due to the rostering restraints, and they didn't kind of go out of their way to actually try and make something work. They just relied on, I assume, the rostering software and kind of the electronic technology behind that to say no to Ms. Fife's request. So the Commission overall found that there was no reasonable grounds for refusal here, and they overturned Ambulance Victoria's original decision. Wrapping up in terms of just the practical aspects of what all this means and what employers can expect in June once these come through, and a lot of this is already relevant anyway, given the flexible work arrangements are already in place. The first one, which has been touched on in repetition throughout this part of the presentation, is that they need to sit down and discuss the request with the employee and consider if there is a genuine alternative agreement that could be met based on the circumstances. Obviously, you're weighing up things like cost, staff, customer service, all those kinds of things, whilst also taking into account the needs of the employee. So, and what caring responsibilities they have, obviously that needs to be taken into account as well, which goes towards the employee's morale and well-being, which, yes, obviously you're going to be weighing up with the costs, any costs and inconvenience overall. But I would say most times, unless you're in a very small workforce, usually that there would be some kind of flexible agreement that could work in the circumstances. Obviously, you've got to be ensuring that your written response is given within 21 days, and that's pretty strict. So don't just sit on it and hope that the employee kind of changes their mind or something. You've got to be actioning it pretty fast in some form. And then just the generic ones, so reviewing and updating any policies and procedures. So we've got a few at the moment, policies which we're reviewing for clients, and we're just making sure that we are adding in those things so that employers know what they can get, and then also both parties know kind of how this is dealt with. Whether it's you in the audience or whether it's someone else in your workplace, making sure that the right people, whether it be managers or decision makers in your workplace, are educated and know what to expect here. And then also keeping detailed records. That's pretty classic lawyers' advice, is to keep things in writing, keep everything recorded, so that if there is a dispute on it, you're protected and you're protecting the workplace from your perspective, because it's all there in writing, and that's a lot harder to argue against than if it's just some kind of verbal back and forth. So that wraps up the substantive parts of the presentation. So I'll pass it over, I think, to Jim. We'll wrap up and then we'll open it up to any questions from you.
Thank you. Sorry, thank you, Matt and Sonia. Obviously, there's a fair bit of information that we've gone through over those 4 key topics that we've covered today. So obviously, it's probably some homework for everyone is, bits of that might not apply, but bits of that obviously will. So we're obviously here to address any questions. They are obviously it is a little bit of a moving piece. Obviously, the 4 topics that we've covered today as well. And obviously there'll be different variants among, you know, the audience today, but we are here obviously to take any questions and address any queries or concerns or any general discussion points that you might actually have.
I think we might have stunned everyone into silence. We haven't had any questions come through in the Q&A so far.
It's either that or information overload. But listen, obviously we are here to take any questions. We understand that for a lot of you, it's probably a bit of homework and a bit of thought. But please do reach out to either myself, Sonia, or Matt with any queries or concerns or any just general discussion points you might have had from today's presentation. Be it obviously on an academic footprint if you want, if that's the case, or any anecdotal example you might want to bring up. From our perspective, obviously they are very important changes. It is like I said, it is a moving piece, and you know, we will be looking obviously at probably revisiting some of the key themes. We'll be running another seminar probably mid-year. I think there might be a Q&A question that might have just come through. Thank you for that, Jackie. But we will be looking at another webinar probably mid-year. We're looking at probably June or July, just in time for the financial year, where we might obviously just bring up a bit of a summary of recent developments around IR, but obviously touching with some other issues that do come up as well. From our perspective, listen, it's always great to present, and particularly, I guess, the topics that we really do enjoy. And like I indicated, feel free to reach out if there are any concerns. But thank you everyone for attending today, and it was greatly appreciated. And thank you so much. Bye, everyone.
Thanks, everyone.
Bye, everyone. See you later.